Thank you for visiting the Foyle Legal website or YouTube channel. Today I would like to speak to you about time limits in respect of car accident personal injury claims in Western Australia. Knowing about this is very important. This is relatively simple information, but if you do not provide information at the appropriate time or start court proceedings before the appropriate time, your claim could be far more difficult or you could end up with no legal rights at all. When you pay the registration on your car, you are also paying for third-party motor vehicle accident insurance. This is liability insurance and not health insurance. It does not cover the person taking out the policy, only the injuries of a person who is injured as a result of the fault of another driver. The injured person would claim under the at-fault driver's insurance policy. The injured person must prove that another driver is at least partially at fault in order to receive compensation. Western Australia has a compulsory third-party insurance scheme, which makes the Insurance Commission of Western Australia the insurer for all third-party personal injury claims. People injured in a car accident in circumstances where they are not at fault must make a claim with the Insurance Commission, and I'll go through the legal requirements regarding this in a moment. A claim can be made by requesting the forms from the Insurance Commission of Western Australia or online at crashreport.com.au. Car accidents are often straightforward and the Insurance Commission admits liability without any difficulties. In other situations, liability is more difficult, such as motor vehicle accidents, injuries to pedestrians, and head-on collisions in rural areas. If it is hard to tell who is at fault, seek legal advice and a lawyer can help an injured person to write to the Insurance Commission. On this slide, I've paraphrased Section 29 of the Motor Vehicle Third-Party Insurance Act 1943. As you can see, the general effect of the section is it says a person shall not bring an action for injury unless the Insurance Commission of Western Australia has been given notice as soon as practicable after the injury. A common situation where the Insurance Commission of Western Australia is not given notice of a claim occurs when a person does not know about the Insurance Commission, they get very little medical treatment and they attempt to get on with their life. They continue to suffer from their symptoms, later on they find out about the Insurance Commission and will try to make a claim. When the Insurance Commission receives the claim, they may say they were prejudiced in obtaining medical evidence and may even say there is no evidence the injuries are from the car accident. Similarly, if a claim is made a significant period of time after the injury, the Insurance Commission may defend the claim on the basis that their ability to defend the claim has been prejudiced. What is meant by this is if notification was made as soon as practicable after the injury, the Insurance Commission can speak to witnesses while the matter is still fresh in their minds. If notification is made months or years after witnesses may have forgotten the incident or the witnesses can no longer be located. Investigating these issues can delay the outcome as considerable time can be spent resolving such an issue in circumstances where it could have been easily avoided. If an injured person does not commence court proceedings within 3 years, it's likely that they will lose their legal right to compensation as the limitation period has passed. It is therefore absolutely essential that if you are injured in a car accident where you are not at fault, you commence legal proceedings within 3 years after the accident. Legal proceedings are usually commenced in the District Court as there is no limit on the amount the District Court can award in a personal injury case. If court proceedings are not commenced before the end of the limitation period, it could mean the end of the claim, or perhaps spending a lot of time and effort in an application for leave to commence court proceedings after the end of the limitation period. The limitation period for personal injury matters and fatal injury matters after 15 November 2005 is 3 years. If the injured person was under 15 years of age when the injury happened, the limitation period is 6 years. If a person is 15, 16 or 17 years of age when the injury happens, An action regarding the injury cannot be commenced if the person has reached 21 years of age. If an injured person is handling their claim themselves, they will often not know and understand the full range of options available to them to improve their situation. This includes obtaining evidence to support a claim for economic loss, obtaining the necessary medical evidence, and appropriate use of court proceedings. A personal injury lawyer can often help you to get more compensation than you can get yourself, and generally the amount that you pay your lawyer will be relatively low, as most of the costs come from the insurance commission on settlement of the case. Foyle Legal is one of only a few firms with experience working on both sides of personal injury claims. This gives Foyle Legal unique insights that are used to make sure injured people get the most out of their claims. If you would like more information, you can call Foyle Legal on 0408 727 343 for an obligation-free consultation regarding personal injury matters. You can send an email to christian.foyle@foylelegal.com, or you can visit our website at foylelegal.com.